However, let's talk about some employees at Costco's regional office here in Ottawa. They're questioning why they're being told, come into the office, because they could easily work from home. As you know, right now here in Ontario, the stay-at-home work order, basically you're expected to leave home for only essential reasons, working from home if possible. But I don't need to tell you, because you know Costco is considered an essential business, primarily selling groceries, and so they're allowed to remain open. So is this a bit of a loophole where they can say to the office employees, you got to come in? Let's find out. Let's bring in employment lawyer Samara Belitzky, associate at Samfiru Tumarkin LLP. Good morning. Good to talk to you. Thanks for your time.
Thanks, Leslie. Good morning.
What do you make of this story?
So it's an interesting situation because, as you said, you have Costco, which is an essential business, but their office workers, under the regulation that the government has put in place, should be working remotely from home unless their work has to be done in person.
So they have a case.
They do, absolutely. So these employees that are being told by Costco that they have to come into the office, if they can do their work from home, the only way that Costco really can find a way around this new government regulation, which requires all employees to work from home unless they have to be working on site. The only way that Costco can get around that is if they can show somehow that these jobs can't be done properly if they're done remotely.
We should say, just to be fair to Costco, they've put out a statement basically saying they're working on it to see how they can put more people at home. That being said, bigger picture now, we're at a point where some employers, essential services aside, can try and make the case, well, they can't work from home, so they have to come in. If you're an employee and you think you can work from home and the boss still says you can't, is there any recourse for you?
Sure, absolutely, Leslie. So there's a couple different things that an employee can do. The immediate suggestion would be talk to your boss, see if there's a way that they'll reconsider, and then it can be resolved that way. If your boss won't do that, if an employer will not allow an employee to work from home when they can, the next step is for that employee to file a complaint with the Ministry of Labor under the Health and Safety Act.
And how long does that take to process?
So in our experience, I'd say in the last 6 months or so, it can take between a few weeks to a few months to resolve, which obviously is not ideal for an employee who may not be getting paid. So the other alternative, which is the more kind of extreme alternative, would be to pursue a constructive dismissal claim.
Okay, so that means, in other words, they use this as an excuse to fire me?
Yes, exactly. So if an employer is forcing you to come into work against the law, that could potentially be a constructive dismissal, and then you can pursue your severance pay.
Okay. Typically, are these the kind of cases you're getting right now since the pandemic hit?
So we have been getting a few of these cases lately. So I'd say in the last few months, it hasn't been as prominent, but that's because the regulations have been different.
Yeah.
Now, with the government coming in with this new measure where it's been mandated by law, as an employee, if you can work from home, you have to work from home. We are getting questions and emails and calls from lots of people who are in the same situation as these Costco employees who are being told you have to come into the office when they can very well do their work from home.
So the onus is on you or the lawyer for the employee to prove it.
That's right. So it's a situation where if the employer, as I said before, if they can actually prove that that employee has to be on site and that they can't do their job properly from home, then there is a way for that employer to get around this new regulation or this new measure. But it'll be very obvious moving forward. And certainly in the people that I've spoken to lately, it's very obvious which employees fit into that category.
Now, I would imagine that there have been some changes since the beginning of the pandemic where the employers were much more patient, I guess is a good word, with people who wanted to work from home. And then suddenly after months and months, they realized they don't get the same productivity potentially here or more, as much work out of the employee. Is that reasonable grounds to try and change the rules? And if so, go to court, who would the employer win based on that alone?
So I think that if the employer was going to try and argue productivity as an issue, they'd have a real uphill battle here because the law doesn't account for a productivity exception. So the law doesn't say, everyone has to work from home unless you're more productive at the office or, at the workplace. The law now specifically says as long as you can do your job from home, you have to, and employers have to follow it and employees alike.
What's the workplace like when you take your employer to court and you win and you're reinstated in there? I can only imagine they don't make it a friendly workplace.
Sure. So the only time that it would be a situation where you would, continue working or be reinstated would be if you file a complaint with the Ministry of Labor.
Okay.
So as I mentioned before, a health and safety complaint, they investigate, they may find that the employee was correct, and then they will order the employer to comply. They might fine the employer in certain circumstances. But if you are pursuing a constructive dismissal claim in court, you wouldn't be reinstated. You wouldn't be going back to work because the constructive dismissal would be a termination of your employment.
Okay. And the compensation typically is how much? I guess it would depend on how long you've been there.
Of course. So in terms of the severance entitlements, it would depend on their age, their length of service, a couple other factors. So every single case is different, which is why it's so important for employees who are in this type of situation to get advice from an employment lawyer so that they know exactly what their entitlements might be.
What if you've worked for a company for a decade and then, the grounds for dismissal kick in? Does that basically kick you out of any compensation because you've broken the rules as they are stated when you come to work?
In terms of the
severance, yeah.
No, so if you've worked for a company for a year and they're, this is a situation where you can work from home, they're not letting you work from home, you could be looking at up to a year of severance pay in a situation like that.
Wow. I thought it was just 2 weeks for every year, but
no, certainly it's not. And that's a very common misconception.
Yeah.
Honestly, a lot of times I hear it's 1 week per year, and under the minimum, the Employment Standards Act, it is more or less about 1 week per year. But when you're looking at somebody's full termination entitlements at common law, they range and they depend on, the circumstances of the situation. And they can be significantly more than that.
Well, and hence the probation period is often 3 months, right? Just so that the relationship, as you pass the job interview and you come to work and things change, they want the right to be able to say, oh, it's not working out, and not have to worry about exactly huge compensation packages.
Exactly, yeah. So you have that 3 month probation, and if you have an employment contract with that probation clause, unfortunately, yes, an employer can let you go within those first 3 months and not owe you that notice or severance as long as it's in your employment contract.
Employment lawyer Samara Belitzky. I always learn when I talk to you. Appreciate it.
Thanks, Leslie.
Samara's with Samfiru